first case before us is State of Ohio versus Christopher L. Robinson. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping track of time. The arguments are being recorded. When you present your argument, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are.
Thank you. Attorney James Reed here on behalf of the defendant appellant Christopher Robinson. The brief just has two assignment errors: the manifest weight of the evidence and the sufficiency argument that you probably see in just about every appeal, a criminal appeal, I should say.
I hate to stop you, but are you reserving time?
I'm actually in a jury trial across the street, so
no.
I'm going to be short and
Right.
to the point. So I will reserve whatever time, but
How much time?
5 minutes.
Thank you.
Okay, sorry about that. In this particular case, apparently there's the victim and the defendant had some type of relationship. A third party was involved. They had some communication issues, and it appears that Mr. Robinson was not happy with the way the relationship was working out. And I'm not going to go through the facts of the case because they're kind of detailed. There was some type of pursuit down the roads, and then the police got involved. I'm really just going to focus on the one issue that I think is questionable in this case, and that's whether or not there was a substantial risk of physical harm, I guess, to person or property. As I understand the evidence presented at the trial, Mr. Robinson at some point claims he shot a single shot up into the air while he was driving, and that's the nature of the one specific charge, which was discharge of a firearm on a public roadway or something. No person shall discharge a firearm upon or over a public road or highway under 23.162A3. And that's similar to the failure to comply statute, almost some of the same language, where it can be a misdemeanor offense or it can be a felony offense, depending on whether the trier of fact determines there was a substantial risk or actual physical harm, one or the other, I suppose. But in this case, I don't think the testimony, whether it's sufficiency of the evidence or manifest weight, when I write my briefs, I tend to be focused heavily on the facts, and then I make these two other arguments, and I've noticed the last couple of times I've done that, the court's declined to address the second part, saying that I haven't developed the argument strong enough. I just want to reiterate orally that the argument, I mean, as I understand it, an appellate court may determine that a trial court's judgment is sustained by sufficient evidence, but may nevertheless conclude that it's against the manifest weight of the argument or evidence. So in my argument, where I'm initially arguing it's insufficient evidence, it's pretty much the same argument as why it's against the manifest weight of the argument. I just...
Counsel, let me ask you a question, because I know what you're getting into, and that is what you're arguing. The fact that he allegedly shot into the air, and there was no evidence that there was bullet holes or any damage anywhere. So the argument I think you're saying is, it was against the weight of the evidence because the only evidence was, and it wasn't credible anyway, that he didn't shoot into the air and shot at them because there was no bullet holes or anything.
The victim, and again, if you've read the brief, you know about the 911 call. There's nothing there, and there's no damage, and they retraced everything, and they couldn't find any houses or vehicles.
Right.
Apparently, he did throw a gun out. They were able to recover that.
And he did admit he shot the gun out the window, but into the air, right?
Excuse me?
He did admit to shooting the
Yeah,
gun.
there is an admission. I guess the one thing that wasn't real clear was there was a magazine, there was one shell casing in the car, only one, and that, whether that was consistent with his testimony about shooting this way and it bouncing off his chest or whatever. But the magazine, I think when they recovered it, had 4 bullets still in it, and I think the testimony, if I remember right, they carried 8 or 9 or something, the magazine. So I'm not, you know, that's obviously a question that either the court could have granted a Rule 29 on that issue about there was no substantial risk, or you get into the second argument that even if you say it was sufficient, it's against the manifest weight of the evidence. That would be my argument.
Well, let me ask you this, because this is something that's kind of fascinated me recently. If you shoot into the air, if you're standing still and you shoot into the air, isn't that different than if you're in a car and you shoot into the air? In other words, if you're standing still, first of all, I'm not even sure standing still would not be a violation, but say you're just standing outside your house and you shoot in the air, okay, as opposed to being in a car. Because in a car, if you shoot in the air and you're driving, I mean, you could hit a bump, you could have any number of things that could happen. Isn't that a lot more dangerous? And wouldn't that be a more risky than just?
Yeah, in either instance, I guess you have no, once you fired the gun, you have no control over where the bullet is gonna land. I think in this, you know, if you're in the middle of a field and you shoot a gun, then obviously there's no harm. If you're driving in a car and you do it, I assume to get somebody's attention in front of you, yeah, depending on the rate of speed, you know, the angle of the arm, there's a possibility, but you know, it's, to me, it's the same like, okay, say I'm driving over in Wayne County and I come up to a four-way stop sign and I run a red light or a stop sign, but there's no other cars on the road. Thank God that, you know, I didn't hit an Amish buggy or I hit another vehicle and, you know, killed somebody. So I guess it depends on, your question is, what level of substantial risk?
Right.
What's the probability?
Because one way of looking at that situation with the four-way stop is you got lucky.
Yeah. And
So.
that, you know, that argument is not new. That's been made before, but in that example. But
Counsel, I know you're going into your rebuttal time, but just in case you don't come back up, I'm going to ask you this question following up on Judge Carr. So, you know, wasn't there a police officer testimony about that risk? The risk, even assuming he only fired once from the window, which was uncontroverted, right? That there was substantial risk created by that in his experience because it could hit anything in the trajectory of houses.
That was probably Officer Siegfried, if I remember right. But as a defense attorney, they testify to that every time I go to court, that, you know, there's a substantial risk. I'm not diminishing it. I'm just saying that's what I expect an officer to testify to, and they do it. If they didn't do it, we'd have the misdemeanor and move on. Okay, you said I already hit my time?
You still have a couple minutes before 5 minutes.
Well, I don't have anything further to add. All right,
You'll
thank
have
you.
5 minutes on both. May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellee, we are asking that this court affirm. Mr. Robinson is challenging the sufficiency and weight of the evidence that was presented to support the conviction for discharging a firearm on or near prohibited premises in violation of 2913-162A3, which was a felony of the 3rd degree in this particular case under subsection C2 because of the substantial risk of physical harm that was caused by the defendant discharging his firearm while he was operating a motor vehicle at a high rate of speed on a roadway that was populated by other persons, including the victim.
in this case who testified that she saw the defendant with a gun. He does not dispute that he had a gun. She heard gunshots. He does not dispute that he fired the gun. She indicated that she heard gunshots on Delia and Hawkins, where it intersects with V. Odom. The defendant indicated he threw the weapon out near V. Odom, which is in fact where the weapon was found. There was a casing found in the car. Officer Sigforth did testify that there is a risk and that he has responded to other calls where shooters have fired out of a window in a vehicle and inadvertently hit things. With regard to the defendant's version of events, which was that he fired straight up into the air because someone had cut him off, even if you believe that statement, you would still only be able to believe one part of it, which would be that he fired straight in the air, because there is testimony that he did not, in fact, fire at someone else who cut him off. He was following this victim. So his own statement is inconsistent, for one thing. For two, as Judge Carr pointed out, it is very difficult to imagine, no matter how good of a shot you are, to fire a weapon with just one hand, even though they're made to be shot, obviously, with just one hand, but you use that second hand to brace it, while you're also operating that vehicle and you're chasing another vehicle. And then to say that you fired straight up, you'd have to be almost leaning out of the vehicle to fully extend your arm to go straight up so that you could avoid hitting anyone else on the roadway, because at any other angle, you could hit someone. And if you're driving a car low to the ground, depending on that angle, you could certainly hit any vehicle that has folks traveling in it where they're sitting a little bit higher than you. So the state would argue, consistent with other cases out of other districts, for example, the 8th District in State versus Brown, that when you're firing across a public road where there are other people present, that in and of itself creates a strong possibility of substantial risk of harm to the other individuals that are on the roadway. Again, just to kind of reiterate, the defendant in this case, it's not one of these situations where we don't have evidence of whether or not there was a gun, or whether or not the defendant discharged the weapon, and or whether it was discharged on a firearm. The defendant admits to all of those things. There are no questions for me.
I was just one question in regard to the statute. It says the fires across a roadway. If he did fire straight up into the air, now I'm not saying he did or he didn't, but that's his testimony, would that negate across a roadway?
I think the statute says on or near prohibited premises, but across the roadway, if there was truly evidence that it went straight up, I still think that it fits within the statute, because straight up can still be technically across if you're in the vehicle next to him. If I'm driving, a Camaro, let's say, as opposed to a Suburban, that attempt to go straight up is still going to be technically across. So I would argue that it's still within the plain language of the statute. If there are no other questions, I would rest my brief. Thank you, Your Honors.
You have 5 minutes.
Yeah, I just need 30 seconds here. I was just gonna, the statute in question, the 2923.162, and I think it's A3, which says this crime or this offense would be enhanced to an F3, but then further in the statute it says, in the absence of substantial risk of physical harm or actual serious physical harm to property, the offense constitutes an M1. That's the crux of what my argument is, that whether it's sufficiency of the evidence or against the manifest weight of the evidence, given the arguments I'm making, that it should have been an M1 conviction. All right.
Thank you.
Thank you.
The court will take this matter under advisement and issue a decision in due course. The clerk of courts will mail a copy